Where did the right to be let alone, privacy concept come from? Imagine a world where your personal life is open for anyone to see, read, or hear about. It would be chaotic, right? Well, that idea of protecting personal space has a long history. It all started with a famous article written in the year 1890 by two legal scholars named Samuel D. Warren and Louis Brandeis. They published their ideas in the Harvard Law Review. This article is considered the first major argument in American law for a person's right to privacy. Warren and Brandeis were concerned about new inventions of their time, like instant photography and sensational newspapers. These technologies made it easy to invade people's private lives without permission. They believed that the law should protect not just physical safety but also mental peace and personal dignity. They argued that invasions of privacy could cause emotional pain and distress that might be worse than physical harm. The phrase "right to be let alone" was not new. It was used earlier by a judge named Cooley, but Warren and Brandeis expanded its meaning. They made it relevant for a society where media and technology were becoming more connected and intrusive. Later, in the year 1928, Justice Louis Brandeis, who was also a Supreme Court justice, wrote a dissenting opinion in a case called Olmstead v. United States. He said that the Constitution implicitly guarantees this right as a fundamental protection against government intrusion. He called it the most comprehensive of rights and the right most valued by civilized men. This idea has shaped how privacy rights are viewed in the United States. Even though the word privacy is not explicitly in the Constitution, courts have used these principles to interpret protections under the First, Third, Fourth, and Fifth Amendments. Understanding where this concept came from helps us see that privacy is a basic civil liberty. It is about protecting individuals from unwanted government or media intrusion into their personal lives. It also supports the freedom of speech and personal autonomy in a society that values individual rights. Today, this means that people have a recognized right to keep their personal matters private. It also means they are protected from unauthorized public exposure or government surveillance. This idea continues to influence privacy laws and protections, making sure our personal lives stay personal in an ever-changing world.